I'm a little bit early. I got 2 minutes, but I'm here hoping I can talk today. I haven't said much today, so we'll see how it goes. Hello, hello. Listen, I am so excited to have a trial that is on my time zone, in my time zone, because this EST, these 9 a.m. EST starts at 6 a.m. for me. So it is always a challenge. Um, Always a challenge. But we got one in LA starting at 10:30. Okay. My kids are off to school. I've done things this morning. I've eaten. I've done a bunch of stuff already. So I am very excited. She said that water is a bad sign. That's it. I just have stuff so that I can speak today. Thankfully, because it's a trial, hopefully I won't have to say a ton. I mean, obviously I'll chime in, but I just have like backups. I got Ricola. I don't even think you can see it. I got my air purifier. I got all the stuff so that I got some Mucinex. I got all the stuff in hopes that I'll be all right today. I feel all right. No, I do feel all right. I may do that a couple times. Can you guys hear me? Sometimes when I re-listen to my videos, it sounds like I'm low to me. Hello. Hey, Miss Tiff. Hello. Oh, do I have DM? Oh, it is DM. Yes, Kat. I turned on the air purifier, and my husband, he was saying that I guess there was a thing where people had air purifiers but never took like the plastic off. So this whole time, they've had it for years, but this whole time it wasn't really working because the plastic was on. I don't really know, but he took it off. He set it up for me so that I can breathe properly. And I got masks. Listen, I did all the things. I was yelled at enough by y'all last night. I did it. I did things. Something that I thought I am going to be sipping though, just to make sure that I can, manage. And we have some minutes. What I was going to say. Oh, one thing that the fit lawyer asked yesterday that I was thinking about after I got off. If you're unaware, there is also a civil suit in this case. So obviously prosecutors chose to prosecute Rocky for the firearm assault, but Relly is also suing him. And so one of the things that came up in the back and forth with the jurors and has just come up, before is it sounds like, or maybe I should say I wouldn't be surprised if that continues to be brought up because they're basically trying to show that he's trying to just get money, like he's after money. So that is something that is going to be brought up during this trial. It was brought up in the voir dire. I think on My Cousin Vinny, they say voir dire. So that's why I always want to say it like that. But anyway, it was brought up during that when they were talking to the jurors. And the other thing that the prosecutor brought up, which was interesting, I don't know if interesting is the right word, but the other thing that he brought up, oh, you know what? Drama. I forgot to get my chocolate. I left the house with my list and forgot to get the chocolate. You said chocolate like 5 times and I still forgot to get it. I'm going to order some. I'm going to order me some chocolate here. Dark chocolate. I'm going to order that. Yeah, so I'm not saying that it's a comparison. I'm saying that they're going to bring it up in this trial to show that he really didn't shoot him, basically, right? That he's just after money. Yeah, I think I'll Postmate some. I was about to say something else. It was about the jurors. Oh, the other thing that the prosecutor said in talking to the jurors, like when they're kind of asking questions, was regardless of what happens, this is what the prosecutor is saying, regardless of what happens after a situation takes place, that doesn't take away from the fact that the incident or the situation happened. And so he was saying to them, regardless of what you hear, are you able to focus on like the actual incident itself and not pay attention to, the stuff that happened after, in order to determine if, if there's reasonable doubt or not. So he was asking him that, but the reason, right, he's asking is because there was police didn't find any shell casings, and they're going to show during this trial, they're going to show the body cam footage, and you're going to see the amount of police officers who were out there canvassing this area trying to find the shell casings. They don't find them. And so Relly goes out there after the police don't find any. Relly goes out there and then he finds the shell casings. So, and then, right, Relly doesn't immediately go to the hospital. He flies to New York, from LA to New York. He doesn't go to the hospital until he's in New York. And so I think he's trying to set up these jurors to, he's trying to, what I realized, especially in being able to witness, it was my first time seeing that process, is the trial really starts in jury selection. And more than just starting because you need to be particular about the jurors you pick, but like the things that you're asking, the things that you're saying, even the familiarity, like they're literally, Rocky's attorney keeps saying Rocky, Rocky. And so it just becomes like and then they're laughing, they're making jokes. And so what you start to see is like, oh, this is the start of this. This is the start of like, see, he's relatable. He's a person. He's you. He's just like you and me. So it was really interesting to see. Fascinating for me, for sure. Yeah, he found them. And then the other thing that I think is this is just my opinion, the other challenge is how grainy the actual footage is. It's just grainy. So is that going to be enough? When they got to the I mean, she was an alternate. I kind of mentioned this a little bit before I got off the line, but the last juror being that a judge, and she was an administrative judge, but like she wasn't a criminal judge. But one of the things she said is, my whole career, he would ask, the prosecutor would ask, again, very fascinating to me, should I be concerned about having you on this trial? Literally, he's asking the jurors this. And so the judge was like, I've spent my whole life like championing, caring about what's fair. So I don't have a problem. Like, it's about what's fair. It's about what's right. If you present it and it's, reasonable doubt or not reasonable, like that's what I do. So it was just interesting. The fact that none of them wanted to strike her was also interesting to me, because you both really believe in your case enough, because a judge, I would think a judge, I don't know. Like, would you want to judge on your case if you're accused of shooting someone? I don't know. Also, a firearms expert. There is a firearms expert on the jury. You guys, firearms expert. So when you play the video of what appears to be a weapon in Rocky's hand, is this expert going to be able to say, yeah, for sure, that's a starter pistol? Is she going to be for sure that's a prop gun? Or is she going to be like, no, that's a gun? Also, in that scuffle, is the firearms expert going to be able to look at that grainy video and have a different opinion than everybody else? So I think it's very interesting. Oh, I still got Postmates some up here. Let me take the Postmates down. I am going to Postmate some though. Let me drink my water too. There's also like a elementary school, I think elementary, like assistant principal. It's just, these are the people, right, that get to hear, and based on their life experiences and the way they hear or see things is going to determine, oh, we're getting close, guys. Let me stop talking pay attention a little bit. They're going to determine what happens. So yeah, they had more strikes. Both sides still. Oops, sorry. Both sides still had strikes. They could have kept going yesterday. Also, Guinea, they got to the point, and after the jury, we're good with the jury. Okay, swear them. And I was like, oh shoot, we're in the moment. This is happening. And they swear them in. And then they immediately, okay, let's go to the alternates. Next numbers, file in. Okay, y'all are here. Let's ask you questions. And then they were good with the first three. I think it was the first three. But that fourth one, they went with her. The prosecution struck her. Then there was a digital marketer, so it was interesting to see who each side wanted to strike, who didn't, who got to stay on. And I'm just so curious as to why. Why are you okay with these people and not, others? Obviously, it's also a gamble because who could be coming next? You don't know. Let me see what's going on since I'm not at the courthouse today. I'm hanging out with y'all so we can watch together. If any of y'all, I'm like watching, but if anybody sees before I do, if anybody sees like, yo, they're live, Mel, just obviously put it in the chat. Let me know. Oh, you know what? I don't know if I did my stuff today. I should do a poll. Would you want a firearms expert on your trial? Would you want a judge, retired judge, on your trial? Hold on, let me make sure. We're also going to obviously depend. We'll get kind of what they're going to lay out during these openings. We'll get to see. Also, the prosecutor is like a well-known prosecutor. He did like Robert Durst or something. The Robert Durst trial. This is the prosecutor for that. So he is also like apparently legit and pretty good. But obviously Rocky's attorney is also really good. Kat said, depends if I'm actually innocent. I don't know yet, Drama, which one I'm going to use. We'll see. Because I know there's a bunch of people up there. There were a bunch of people who are planning to stream it. So I just need to see. And since I'm not there plugged in myself, it's not my, I'm not going to get a clean feed. Let me see if I can do this. Oops. I want to put. I always forget how to do this. Engage, start a poll. I'm going to say, if you were Rocky, okay. Yes. Yes. That's true. That's a good point. We just getting started, girl. You ain't late. We just getting here. Oh, Megan is there. I just looked at Megan's stream. She says she's in the courtroom waiting for the stream to start. The jury isn't in yet. The judge says there's an issue about a late ballistics report. I don't know if I talked about this too, but on the first day before they even started jury selection, there was, I think I talked about it maybe in the stream, there was some back and forth about the starter gun, prop gun situation. The prosecutors didn't know that until Sunday or Monday, because Monday was a holiday. Hold on. Let's do one crime. Hold on. Sorry. Let's go.
The two casings are consistent with having been fired for 9mm casings from certain 9mm handguns. There are some markings on the casings that are somewhat unique, and they can basically track them down to a much smaller subset of firearms that could have caused the marks on the casings. Included in that is Glock 43. So, hold on, okay.
Did the report say that the casings could only have been fired from a Glock 43, or could a Glock 43 be among the type of firearms that the expended casings could come from?
Let me read the exact conclusion. Items 1A and 1B.
Firearms that the expended casings could come from.
Let me read the exact conclusion. Items 1A and 1B.
Those are the casings.
I switched to Associated Press, but the audio is worse, right?
Aftermarket slides or a series of subcompact pistol frames, including but not limited to polymer model PF9SS, Glock store model SS.
Wait, slow down because the court reporter needs to take it.
Sure. Polymer. In fact, oftentimes and frequently when you're looking at casings, you're not able to get a whole lot of information. But it turns out that the markings on these casings are a bit more unique, and they are not only consistent, but the examiner will testify that the markings he has seen very rarely, and that where he has seen them, where they've been reported, are with a Glock 43 pistol.
What's the name of the examiner who did this ballistic comparison?
The examiner's first name is going to be F-I-D-A-L, last name B-I-R-A, I-M-A-H.
B-I-R-A.
I-M-A-H. So the way this came about was, we were looking at a different issue. The detectives yesterday afternoon sent an email to my co-counsel basically saying, hey, take a look at that report, this report we're talking about, which is in the attachment.
Detective Flores. Flores. From every homicide?
Yes.
Go ahead.
So when this was received, my co-counsel looks and says, I've never seen this report before. So he goes back in discovery, looks in emails, we don't have a report. So we instantly contact the defense, send them out the report. I want to be clear, the report is inculpatory, not exculpatory. So obviously, not only do we have no motivation to have not turned over the report, RHD has no motivation either. What's very clear is that they believe they had turned it over, and they did it.
What time did Detective Flores bring this to either your attention or Mr. Frizzone's?
Yesterday afternoon, you want the exact time?
Approximately.
It was yesterday afternoon, we were in court. We went back to the office after court yesterday, and that's where, we went back and looked to see, do we have this discovery?
So something after 4:30 PM?
The email is timestamped 3/18, but I got it when we, so it was essentially received but not gone through yet until I could get back over to my desk.
You conveyed this to the defense when?
We sent it to them at 5:21.
So about 40 minutes later, they're done?
Because the first thing we had to do was, we had to go back and see, or have we already turned this over? So we not only emailed them, we called them. We explained the situation. The response at the time that we gave it to them initially was, well, this is the same thing that you have accused us with respect to the witness and the court's finding that they violated the court discovery order. And we responded, no, this is completely different. You had interviews starting last August.
I don't want to get into who said what. I just want to know the sequence of events.
So at this point in time, we had a discussion. We sent an email at that point to counsel, and we included the court. There was an email sent late last night at some point by Mr. Tacopina. I did not see it until somewhere around 2 in the morning. In that email, Mr. Tacopina cited the Hughes case. There were no facts in the Hughes case. I went in the middle of the night, I got the case, I read
I
it.
don't want to know about, this would be appropriate if you want to argue your position. I just wanted to know the sequence of events.
Right, I'm not gonna go any further other than to tell the court. I read the case, I then sent an email at roughly 3 or 4 in the morning. I sent it to counsel and I sent it to the court.
Just one last factor on it, which is, I knew from past experience with firearm analysis that there would be a lab file or bench notes associated with the analysis. So I tried to immediately contact the lab to expedite and see if they could send that to me immediately, but they were not open at the time that I called. So we had to call this morning at around 6, and they scanned it and sent it over, and I sent that to the defense as soon as I got it.
How many pages is this report?
The report is one
The
page.
report itself is one
It's
page.
One page. How many pages are there total of all the police reports, all of the discovery in this case? How many pages?
Regarding this one,
Regarding the total number of,
regarding this one.
No, I was,
no, the total number of pages involving this case and this investigation.
I would estimate 100 or over 100 pages. To be totally candid with the court, I haven't counted them, but that's just ballparking the various reports, and things that we received.
All right, I understand now the sequence of events, right? Who wants to speak to the defense?
I think, I'll start, maybe Mr. Siegel, if I leave something out, we tackle this together. I mean, we spent literally the night before, about 5 hours.
Okay. Speak slowly, the court reporter needs to get everything down, and I want everybody to know exactly what you have to say. Go ahead.
So, and I'll just stick with sort of the chronological order here. I'm not going to argue case law or anything like that, but aside from the fact that we lost 4 to 5 hours the night before opening dealing with this, we this morning, after we get an expert report last night that was in the possession of the lead case detective in this case, not some random police officer. Detective Flores is the case detective in this case. I have to believe he understood the importance of that report. He testified at preliminary hearing. This morning, we got another 28 pages of backup data. on this. Backup lab, I guess, report that normally comes with a conclusion report. We got this morning. And I find it hard to believe that the lead detective in this case didn't bring it to anyone's attention from the district attorney's office until after a jury was impaneled the night before opening statements. I mean, something that they now are saying is such a crucial piece of evidence. We have an issue now with the jury, obviously it's a jury panel. It may affect, quite frankly, whether we would have kept or not kept a few jurors, one in particular. Then we assured him yesterday he'd have a fair trial. You're gonna have a fair trial. We've made issues regarding the veneer, you know that, or I'm not gonna rehash that. We're here, we're ready to open today. I don't even know how we're supposed to do this. This should be suppressed without question, because it changes the complexity of the case. At the very least, we have to quash this panel and start again, or strike jurors, reselect. I mean, I think, say, okay, well, continuance is appropriate. We pick the jury. We're ready to go. This is something that, you know, to lend a fair and effective representation here, as we all assured Mr. Mayor we would have, in the midst of a trial that's already underway, we would need to locate and retain our own expert to conduct a scientific analysis. Their report was 28 pages. It took them, according to them, it took them 1 week to do this. 1 week. And that's their own lab, with their own on-staff experts. And it took them a week. How long is it gonna take us? We have to go find somebody first, hope he's available, the trial will be over. We also have to make arrangements for the physical examination of the casings, scientific testing. I mean, if you look at their report, I mean, they cite like some of the basis for their findings is the internet. They went on and cited all these websites and forums. I mean, there is so much work to be done here to even understand this conclusion. I mean,
All right, so what do you see?
what am I seeking?
What are you asking for?
Your Honor, I'm asking, well, and our letters laid it out, I don't need to rehash it, but our letters laid out pretty clearly what we're asking for. There's no way to proceed in this case if this is admitted. We have to either strike this whole panel, we need a continuance, we have to start again. What I'm asking for is you include this. This is after the jury was impaneled. This is a major piece of evidence that will require us to do a lot of expert work that took them, their own department, week to do. That's the only thing I'm requesting. Short of that, Your Honor, I can't even open if this is coming in, because I have to deal with the address, I don't even understand it. And it's, on the written report, we have 28 pages of backup data. So that's what I'm requesting. I'm requesting this to be included. It's after the jury's impaneled here. You know, as Steele just pointed out, there's also a balancing argument under 352. You know, which I think is also something that's relevant here, including not limited to, but you know, we have this whole, I don't even know what to say here, Your Honor. I really don't. I want to make sure he gets a fair trial. He's here, we're ready to go. We all assured him he'd get a fair trial, and this is, I've never seen anything like this. I'm not gonna talk about the other witnesses, the late Brady disclosures, or the witness we got the name of for the first time last night. I'm not whining about that. I know that's what they want to keep doing. We both have had issues with that. That's fine. I will not make it an issue of it anymore. You've already ruled on that. Period, end of story. This is now a new one. You know, I don't want to get into, I told you so, but many people said to me this morning, I told you so, that this was gonna happen. And I'm trying to keep my composure, Your Honor. I don't know if I've ever been this upset in a courtroom in my whole career, both as a prosecutor and a defense attorney. I gotta be honest with you. It's not right, it's not fair to anyone.
Hold on. Mr. Siegel, did you want to?
Yeah, the only thing I wanted to say,
I don't want you to repeat what Mr. Tackett said. If you want to add something new,
no,
yeah,
you're welcome to it. I want to add something new. Go ahead, dovetail what he said with respect to the 352 arguments. And that is, the report says that the characteristics include are not limited to certain firearms. That means the universe of firearms in this case, based on the face of that report, is extensively broad. So given that, Your Honor, I think even just the probative value of this is substantially outweighed by the danger of undue prejudice, separate and apart from the late disclosure. So it should be excluded on 352. But that's secondary to the fact that it's just incredibly late at this stage for all the reasons exactly said. So I'm just adding that additional factor.
All right, what I'm hearing from you then, it seems like you're talking out of both sides of your mouth with the defense is like, it's irrelevant. However, it's so prejudicial that it shouldn't be allowed in. It's so inculpatory that it shouldn't be allowed in.
No, I don't think anyone said it's so inculpatory. We don't understand. Saying it's inculpatory is not accurate. No, I didn't say it's inculpatory, he didn't say it. What he said was it's a balancing test, because it says including but not limited to. All that simply means is, not that it's not inculpatory, not that, we just don't understand what this means. Not limited to means there's a universe of guns that have to be tested now. I don't know what not limited to means. So how many pistols does not limited to include? How many firearms does not limited to include? That's what.
I'm stopping just for a second to try and get us caught up, so we'll be slightly behind. But basically, there, as we know, right, there were some shell casings found by Relly. It sounds like, from what I'm seeing and reading from the Black Letter Law, who I met, who's at the courtroom, is that there is a newly discovered report about the 9mm shell casings that Relly found, that the state says they just found last night. They immediately notified the defense and the court about the oversight. So there is this ballistics report, essentially is what that means, right? They found some shell casings. They somehow did some kind of report. And so they want to get it admitted. The defense is saying, we just got this last night. This is Brady material. It needs to be excluded. So the defense is arguing, don't let this in. And the state is like, my bad, we found it last night. That's like the basis, but we have to keep listening to try and get more.
It includes so many other guns that it should be kept out as being irrelevant. But what's very clear is, and I didn't appreciate the comment, when Mr. Tacopina suggests that he can't believe that the DA's office did not know about this in advance, when I spoke to him on the phone last night, that is not what I heard. What I heard was say, listen, this is a problem for us. We understand, I'm going to quote Mr. Siegel, yeah, there's no reason why you would have not turned this over if you had it, which is correct, and the record would support it. Comparing this, counsel is now discussing and saying how they are being victimized by late discovery. The only late discovery in this case, and the court's aware of it, the court ordered that the discovery be turned over on 2 witnesses. It should have been turned over before the court ordered it.
I don't want to deal with something that we've already dealt with. I understand about the 2 defense witnesses. We've covered that. Just deal with the present issue.
So what counsel did is, he cited last night, he sent to the court a case called Hughes, 2020 case, 50 cal at 5th at 257. He included no facts about that case. At 2 in the morning, I went and I read the case, and I then sent an email. That case, so the record is clear, involved a situation where there was a Watson murder, and where the defendant was being tried on a theory that his alcohol intoxication had caused the accident. Investigation had been done by the MATE team, and they had determined that in fact it was speed and not alcohol. This was a very huge problem for the prosecution because that was the theory of their case. Apparently, the head of the MATE team started redoing a separate investigation, which the evidence suggests the prosecutor was well aware of. At the very least, and as the Court of Appeals said, the prosecutor was given information that in fact the MATE lead detective now had a new opinion contradicting the prior opinion that in fact, in actuality, it was caused by alcohol and not by speed. Instead of turning this over to the defense, the prosecutor literally had the witness on the stand in front of the jury. He then pauses looks over the fence and says, hey, by the way, here's the diagrams and here's the information that he's gonna be testifying to. Defense is obviously horrified because it's the entire case. The defense asked for a mistrial, they asked for a continuance, they were both overruled. The Court of Appeals said, hey, listen, obviously the suppression of evidence, as the court is aware, not the statute, is the last option a court can utilize, only after every other option has been determined to be not harsh enough or not accurate enough in addressing and solving the situation. Court of Appeals said, hey, listen, Judge, you had a chance to do less remedy, you didn't do it. The jury ended up convicting, and the case was reversed. To compare that case to the facts of this case, it is distinguishable for the following. Number one, that evidence was not just inculpatory, it was the entire case. Number two, the prosecutor, for a tactical advantage, which the Court of Appeal basically said in a footnote, that although the original trial judge had found no prosecutorial misconduct, that in essence the record didn't support it, meaning that there was misconduct that the prosecutor did. The prosecutor decided, for a tactical advantage, that he was not going to turn it over. He then did it while the witness was on the stand. He then opposed any continuance or mistrial. Here's what we have. We have evidence, which it is inculpatory. It's inculpatory because the defendant is found at his location, at his house. There is a 9mm magazine for a Glock 43, and there's no Glock 43 to go with it. So it's just a magazine. We already knew that the defendant had the Glock 43 magazine, and we knew that these were 9mm casings. The difference now is that there's going to be evidence that suggests that a Glock 43 is more likely to have put the marks on the expended casings than many other firearms. So the idea that this would be excluded under 352 is patently absurd. The idea that Hughes is in any way authority for what they're asking is also absurd. We talked to the lab this morning. First, what we are proposing is that we will not mention this evidence, in this case, in opening. We will wait and see how the case develops. As the court is aware, and the court is aware of this from the discovery of the witnesses that we got the day before we started trial. The defense is now claiming not only that it was a starter pistol, but they are claiming that the 9mm magazine, which was found at the defendant's residence, actually belonged to the defendant's manager, and that he is going to testify. So let's look at how this plays out. If the defense ends up being that, in fact, this 9mm magazine belongs to the manager, that in fact, what was used at the scene was a starter pistol / prop gun, then although we don't believe that's credible evidence, that is where they're going. So here's what we're asking. One, there's no late discovery instruction because, as the court is aware, and maybe counsel is not, to have a late discovery instruction, the court has to find that we had the information and didn't turn it over. There's no reason why we wouldn't turn it over, and as soon as we had it, we turned it over. And as the court's aware, I've been trying cases in front of His Honor for going on 30 years. As soon as we found this evidence, court, we contacted counsel. Number two, the lab has told us that basically what they did in this case, to have someone else examine it, it is a very quick examination, and the amount of time that it should take for someone to examine it and end up being able to assess whether or not LAPD was accurate in what they found, is ranging from a few hours to maybe a day. This is what we would propose. We would propose that at this point in time, we will not mention this in opening statement. We will see how the case develops. We will, if we believe that this is evidence that is going to be important, we will ask to admit that evidence later on in the trial. In the meantime, we will make arrangements for counsel, and they can hire any qualified firearms expert. I want to distinguish between Hughes and this case. Hughes was an extremely complicated accident reconstruction involving a vehicle where multiple individuals died. It was very time consuming. It's an extremely complex investigation. This is very minor and simple ballistics interpretation. So we will make it available. We already have sent our investigators to recover the evidence. I don't know if they already have it. We believe they already have the evidence. They have it with them. And we will get it to the defense. I just, this is related to the other issue, so I just want to make sure that this is clear. Counsel seems to be under the impression that the court has now changed its ruling and that we are not allowed in our opening statement to address the idea, which the court previously ruled we could, that we did not find out about this defense until the 20th. The court had said previously on the record, yes, Mr. Lewin, you guys can address that issue in opening. I will decide whether I'm going to issue a discovery instruction later. Counsel believes you've now said we can't do that.
I did say that.
Yes, they did. Yeah.
I did. I had said yesterday that the purpose for an opening statement is to give the jury an idea of what the evidence, what you believe the evidence will show. Talking about late discovery, that's argument. So as far as your opening statement, I don't want you to mention anything about, you just found out about a starter pistol. That is not part of what the evidence will disclose. I talked about that yesterday.
So, but I'm correct. The court's original ruling was.
Yeah, that is what I said. Originally, I said, yes, you can bring it up.
Okay.
But then after thinking about it, that's not part of an opening statement. So I don't want you touching it.
Okay,
Go on with the present issue about the ballistic.
So where we sit right now is that counsel is arguing two inconsistent positions. They're arguing that this evidence is so damaging that we have to start over. Now, that's not in a vacuum. It's very clear that the defense is not happy with this jury. They made it clear.
Hold on.
No, don't
Okay.
interrupt.
Okay.
He didn't interrupt you, don't interrupt him.
It is very clear by the comments the defense has made in court, where they have repeatedly said that their client is not getting a fair trial because of what they believe is the composition of the jury, the fact that they have filed a writ, the fact that they have continued to bring this up, leads to the inescapable conclusion that what they are looking for is a way to start over. I believe, Your Honor, that what we have proposed is more than fair, because in the end, Your Honor, they're arguing it both ways. As the court mentioned before, I ever pointed out, they're arguing, if you let this in, Judge, my client can't get a fair trial. Oh, by the way, what's the value of this anyway? What does it matter? Again, my position would be the second argument is inaccurate. It is evidence that is helpful to our case. It doesn't prove the case by itself, but it is definitely helpful. It is not irrelevant. It's not too.
All right, you don't have to go on.
Okay.
I believe I have enough information to make a decision.
Have you heard police on?
No, you can't.
I can't respond to what he just said about the jury.
It doesn't matter about what he said about the jury. That has stop. That has no bearing on any decision I'm gonna make.
There's a record though. There was a record.
I don't believe that you are unhappy with the jury. Mr. Lewin might say you're unhappy with the jury, but I don't believe you are. If you were, you wouldn't have accepted the jury. I believe that both sides are satisfied with this jury and that both sides will get a fair trial. You don't need to respond to it because it doesn't matter whether he does or does not think you're happy with the jury. I believe that you are satisfied with the jury. All right, here's the way I want to deal with the latest, recently finding out about this ballistic report. Everybody at the table, all counsel, to me, has great credibility. I accept what all of you say. I don't believe that there's been any nefarious conduct by anybody. If this late report involved, all of a sudden it was disclosed that a witness, an additional witness positively identified Mr. Mayers as the shooter, that would be very critical and crucial. If a witness came forward and said, yeah, Mr. Mayers confessed to me that he shot ASAP Rowan, that would be very critical and crucial. If a firearm, if a 9mm was recovered, that could be ballistically compared to the casings, and that just became discoverable or became disclosed, I think that would be critical. But that is not what happened here. What I'm seeing here is that the casings that were recovered were examined, and the opinion is they could have been fired from a Glock 43 or any other number of types of 9mm. You have said that, well, now you want to hire a ballistic expert. That's not fair to you and your client. So this is what I am proposing. We have a list, a Superior Court list of firearm examiners that have been recognized as experts. My star judicial assistant over there, Alice, will print out that list. Ms. Kaplan is an attorney who practices in this area. If there is someone on the list that you want to hire, contact that person and tell them this is crucial that the ballistic evidence be examined now, not later, but now. The court will pay for it. Mr. Mayers will not have to pay for this. We will. If the firearms examiner wants extra money because it's a rush, the court will pay for it. If you are not satisfied with the people on the list, then if you want to find your own examiner who will do the examination, the court will pay for it. If it's necessary that I speak to the examiner to impress upon the examiner the importance of getting this done ASAP, I'm glad to do that. I am providing my cell phone number to all of you. If you need to call me any time of the day or night, I will speak to you. I will speak to a firearms examiner. If you feel it is necessary, Mr. Tacopina, we can be dark on Monday. But I'm not excluding the evidence. I don't find that there is any nefarious conduct. The evidence is relevant. It's not a smoking gun, but it is somewhat inculpatory. But in and of itself does not mean that your client is guilty. That's the way we're going to deal with this. That's the way we're going to deal with this.
Yo, what's happening?
Are both sides ready for the jury to come in? Do not mention anything about the ballistic comparison in the opening statement.
That was our question.
So,
Yeah, do not mention that.
Understood.
Your Honor, what I was planning on mentioning was that the cartridges found at scene were 9mm. In the defendant's house was a magazine that was 9mm.
All right.
And had some 9mm live ammunition in it. That was it.
If that has been part of the discovery and that was known, then that's fair game.
Yes.
But this ballistic comparison, that's off limits for the opening statement.
Yes.
Understood.
All right, bring in the jury.
I think that you're gonna print the list for the.
Oh, yeah, do you want that to Ms. Kaplan, the list
Okay.
of the firearms counter?
I could also email it.
Stop this.
Just, print it. Yes,
Let me see. Okay, I can pause. Okay, that other one wasn't letting me. Okay, so let's just be clear. Let me give you a recap so we're clear. Yesterday, the prosecutors gave over this ballistics report. Okay, so we know that the gun has not been recovered in this case, and police didn't find any of the shell casings. ASAP Relly found the shell casings after police searched, right? So he found those shell casings. He's turned them in like 2 days later to the police. And so prosecutors are saying last night, a detective, the lead detective was like, oh my gosh, you guys, we have this report that shows that the shell casings that ASAP Relly turned in came from a 9mm, a Glock 43 or any other type of 9mm. That's what their report says. The reason that's a problem is because when ASAP Rocky, I'm assuming, was arrested, when they went to search him, relation to this case, they didn't find the weapon, but they found a magazine. Okay, a magazine which had live rounds in it and was for a 9mm. Okay, so they find this magazine for a 9mm and it has live ammunition in it. Okay, and so what they're obviously saying is they're going to make this connection to, we found this magazine at your house that matches or could have, could match the shell casings that were found on the scene by ASAP Relly. Okay, you guys following? Here's what they started to get into, and this is what's really happening, in my opinion, and I'm not a lawyer. Remember, Tuesday was the first time the prosecutors had ever heard about this starter pistol. Okay, it was the first time. Up until then, it's just been, we have this gun and this is what happened. Tuesday or Monday, whatever day it was, they get notice, right, that the defense and are going to call two witnesses that says Rocky walks around with a starter pistol. So that comes out, and now all of a sudden, well, we found a ballistics report that actually could be from, right, could show that the magazines at his house match the shell casing. So they're essentially trying to refute. They're trying to come up with a way to discredit this starter pistol, essentially. And that's what this is, basically. So what he was trying to do, the prosecutor was like, well, we just found out about their stuff on Tuesday. And the judge is like, I already dealt with that. We already talked about that. I don't care what you found out on Tuesday. We're talking about this right now. So that's essentially what they were going back and forth on. The other thing is, originally, the judge said, prosecutors, you can talk about in your opening statements that they just told you about this starter pistol. You can say it was late. They just made this up, essentially. But then the judge changed his mind and said, actually, you can't talk about that. And so the prosecutor seemed to be confused, thinking he could still talk about that. And the judge said, no, you can't. So that's essentially what that back and forth was. It was, oh, shoot, the defense just came up with something we were not prepared for. Oh, shoot, we just got this from the lead detective last night that the shell casings seem to be connected, could be related to the magazine that we found at Rocky's house in his possession that had live ammunition. Does that make sense? Are we all clear? Also, I'm gonna get back to it, but this judge, from what I was experiencing, I wish I was here for all of that, but from what I was experiencing, he was laughing and joking, and he also didn't have time for games. Yeah. I didn't say that. I said, sit down. Yeah, let's talk about, okay, we're ready to go, and I'm not gonna go back and forth with you. Those were the vibes. And so at the end, what he just said was, Rocky, because I agree that this is, late for you and this matters for you, you can choose a firearms expert or analyst, or what did he say? An examiner. Basically, you didn't have time because you just found out about this. So you can get your own examiner to basically refute what the defense is, what the state is saying. You can get your own people to look at this. We have a list of people you can choose from, or you can choose your own. The court is going to pay for it because they were asking for this report, this ballistics report, to not be included. But the judge is like, no, it's going to be included, but you can have somebody of your own look at it and we'll pay for that. And he even said, if you need Monday to do so, we can go dark, meaning we won't have court. If you need Monday to do all of this, we don't have to have court on Monday to give you time to do it. That's essentially how we ended. Okay. Hey. Yeah, so what they would do if they're alive just means that it's not spent. It hasn't been fired, right? If you fire a round, what comes the bullet, but then you have the shell casing, right? And so what they would do is they can fire, I'm assuming, one of the live rounds to see if the shell casing that comes out matches. I don't really know how they're gonna do that because I'm not a lawyer or a firearms examiner. But let's get back to it so we're not too behind.
If you
Oh, it looks like there's still. Oh, hold on.
A real and/or you gave to us during and/or that you gave to us during jury selection. We all understand that was a long process, and we appreciate your attention. After going through that long process, I'm sure some of you are thinking, wow, this must be a difficult case, or this must be a really complicated case. And to be fair to you, if I was sitting in your position and I looked out on the number of jurors that we started with, or even the number of attorneys that are up here, I'd probably have the same thought myself. But what the evidence will show in this case, and what will become almost instantly clear, is that this is not a complicated case. The evidence will show that the events in this case were captured on surveillance video. I'm going to start this whole presentation out by playing the video for you. So you will have that frame of reference as we're talking about different features, the people that were involved, the locations that are involved, and what happened. You will already have seen the video. The first video that I'm going to show you was captured on November 6th of 2021 at around 10:10 p.m. just outside of a parking garage entrance, mid-block, so on Argyle, in the middle of Argyle, between Hollywood Boulevard and Selma. The second video that I'm going to show you was captured 7 minutes later, so at 10:17. It was, if we're being generous, 2 blocks, maybe 1 city block away from the first location, down Argyle, around Selma, at a small intersection called Selma and Vista Del Mar. So I'm going to play the first video for you, that outside of the parking lot.
These are the videos that were in the preliminary. You've probably seen these.
Now I'm going to move to the second location, that at Vista Del Mar and Selma, and I'm going to pre-warn you, it's a little small, it's at a distance, so you're going to want to focus your attention at the top left-hand corner. All right, now let's go over the details. As I said, the people that are involved, the location, and I'll give you an explanation of what you've seen on these 2 videos. This case takes place in the heart of Hollywood. This is the iconic Hollywood and Vine. The picture you see here is just a demonstrative picture of that intersection, but it's an iconic intersection in Hollywood. That intersection is about 1 block one block west and 1 block north of the crime scene. So for those of you who are familiar with Hollywood and that intersection, it's a pretty big landmark, and that's where I want to focus your attention. Now, the actual shooting in this case takes place on a much smaller street, Selma and Vista Del Mar. But this is the area around where that shooting took place. It is a very densely populated part of Hollywood. And there are some landmarks on there that you might be familiar with, just so that you can familiarize yourself with the location that we're talking about. The Capitol Records building at the top, the W Hotel, and Hollywood Boulevard. The shooting, as you've seen, occurred just outside of a parking lot on that corner of Vista, Del Mar, and Selma. That was a parking lot at the time that was full of cars. And it was ringed by a nightclub on the corner, a sound studio, a hotel, and 3 different apartment buildings right around. As I said, densely populated. This was also Saturday night. Saturday, November 6, 2021 at about 10 p.m. in Hollywood. This is a time that Hollywood is busy. Now that you understand kind of the locations that are involved, I want to start with how this case starts for LAPD.
Hi, I live in the apartment on the corner of Argyle and Selma in Hollywood, and there's just been a shooting.
So at 10:18 p.m., LAPD receives this call, that there's been a shooting at the intersection of Argyle and Selma. The call continues though.
Did you see anything or you just heard it?
Yes. No, we watched it.
Okay, what did you see?
There were 4 men, and they were kind of fighting as they were walking along Argyle, and then they turned left onto Selma. We heard yelling and they started running, and they turned left into the back lot apartments for El Centro Apartments.
Now, the 4 men that you see on that screen will be the 4 men that we'll talk about in a minute. They were the 4 that were at that location.
I'm right with that.
The guy in the black sweatshirt pulled out a gun.
Okay.
And he shot, and I think the guy who shot was blue.
Now, the evidence in this case will be that the man in the black sweatshirt was the defendant, Rakeem Myers. That evidence will be uncontradicted. As you have heard throughout jury selection, Mr. Myers is an entertainer, and he goes by the stage name A$AP Rocky. You will hear other nicknames that he is referred to in the evidence in this case, including Flacco and Luigi. At the time of this crime, Mr. Myers was 33 years old. He has his own company that I believe is referred to as AWGE, A-W-G-E, that you will hear referred to in the testimony in this case. And as we've talked about, his significant other is Rihanna. The victim in this case is a man by the name of Terrell Efron. And Mr. Efron, you will hear, was also a member of the A$AP Collective, and he went by the nickname A$AP Relly. Mr. Efron was also 33 years old at the time of this crime. And what you will hear from Mr. Efron is that he was friends with Mr. Myers well before this case and well before even Mr. Myers was a famous individual. That essentially, I believe they met in high school and grew up together. He has known Mr. Myers 18 or 19 years at the time that this shooting happens. And you will also hear that he, too, at the time was working in the music industry, and he had his own company called Shut Eye Entertainment. Now, I mentioned it already, but to put a finer point on it, the group that both of these men were members of is called ASAP. It doesn't stand for what you probably thought it did when you walked into court. It's an acronym for Always Strive and Prosper. Was formed by high school age kids in Harlem, New York around 2006. They call themselves a collective. You will hear are rappers, producers, music video directors, designers, people that have different artistic pursuits that essentially work together. And there are many members of ASAP. The ones that you will primarily hear in this case are obviously Mr. Mayers, the victim, but also the two friends that were with Mr. Mayers at the time this happened. And they go by ASAP Ills and ASAP 12E. And I will just pre-warn you that 12E gets spelled a bunch of different ways. It's not always consistent. And there will be one last member that you'll hear about briefly, who goes by the stage name ASAP Bari. Sometimes people refer to him as Young Lord. As I said, the four main members of this group that you will hear about are these four men. The victim is on the far right, Mr. Efron. The defendant is the next person to his left. As I said, ASAP 12E, his given name is Jamel Phillips, and the last is Elijah Ulanger, who goes by ASAP Ills. And these were the four men who were present at the time of both of these incidents. Now I want to take you to that weekend, Saturday night in Hollywood. There was actually at the time a music festival or concert series going on known as Complex Con in Long Beach. And you will hear that Mr. Mayers was to be a performer at that event the day after the shooting, the Sunday, November 7th. Now, although I told you that Mr. Mayers and Mr. Efron were close at one point, you will hear that throughout their relationship, there was tension between the two of them. And that tension was essentially building up to the night of November 6th, 2021. You will not hear all the reasons why there was tension between the two of them, but we will get to the point the day before this shooting, November 5th, 2021, when that tension kind of comes to a head. What happens on that day, Mr. Efron will tell you, is that he is in a car with that last member of the ASAP group that I talked about, ASAP Bari. The two of them are driving when ASAP Bari receives a phone call from Mr. Mayers. And ASAP Bari takes that call on speakerphone. So Mr. Efron, who's in the car, can hear both sides of the conversation. He can hear Mr. Mayers and he can also hear ASAP Bari. And in the course of that call, Mr. Efron, the victim, heard the defendant saying these rude and aggressive things about him. Mr. Mayers at the time does not know that Mr. Efron is in the car with the victim. This leads to the next day, November 6, 2021. You'll hear that Mr. Efron was in Los Angeles working with one of the artists that he managed. He was asleep around 9:00 p.m. when he started receiving a series of urgent messages from not only from Mr. Mayers, but from the two other men that were with him, ASAP Ills and ASAP 12. And you'll hear that he received a number of calls kind of back to back to back from the three of them. Now, he didn't answer those calls because he was sleeping, but when he ultimately woke up, he saw that he had a number of missed calls. He also received text messages from Mr. Mayers that were aggressive, seeking a confrontation with him, asking him where he was. Mr. Mayers is on the left side of this conversation. Where are you at? Let's get to it. stop ducking my calls. The messages that the victim's receiving are instantly aggressive towards him. So you will hear from Mr. Efron that he called the defendant. He was groggy because he had just woken up. They had a conversation and they agreed to meet outside of the W Hotel in Hollywood. Mr. Efron will tell you that as he went to that meeting, he was of the frame of mind that he and Mr. Mayers were going to have a confrontation. That he believed they would argue, and that ultimately this would lead to kind of repairing their relationship. So they would each be able to speak their piece and essentially fight like brothers do, and that it would ultimately bring them closer together. They would repair sort of the issues that they each had with each other. So that's how Mr. Efron is going into this meeting. Now, let's talk about the location where they meet, this location just outside of the W Hotel. You're going to see this map throughout this case. So I want to take some time to walk through it with you so you understand the various features that are depicted here.
Completely not consequential, but one of the jurors worked at Trader Joe's. I can't remember if he was dismissed, but he was a manager at Trader Joe's. So
on the left side of the screen is Argyle Avenue. On the bottom of the screen is Selma Avenue, and on the right side of the screen is El Centro Avenue. Now you can't see it in this map, but if the map were to continue off the top of the screen, Hollywood Boulevard would be just above that. In the middle of this map, there's a small street called Vista Del Mar that kind of goes north and then forces you to go east. The red arrows that you see here are the path of travel that Mr. Mayers took that evening. So it starts at that mid-block location on Argyle, continues down to Selma, and then up Vista Del Mar, around that corner, all the way to El Centro, and then he made a left turn on El Centro and went above, off the map. The numbers in the red boxes that you see here, 1, 2, 3, and 4, are the 4 different locations where the police were ultimately able to recover surveillance video from. There are 4 different locations. Attached to each one of those locations, you'll see the green triangle and the green, and with a green arrow in the middle. And what that represents is very roughly, this is not meant to be, exact, but very roughly the direction that a camera attached to that building was facing. You will also hear that locations 1, 2, and 4 captured video only. But you will hear that the location with the number 3 captured both video and audio. So I told you there's 2 incident locations, 2 altercations that happened. The first happens where the yellow box is right now, right outside of that parking garage. The second happens at that corner of Selma and Vista Del Mar. And that's where the firearm was actually discharged, where the gunshots were fired. So the first location I want to focus on is that where the initial confrontation happens. This location is the entrance and exit of a parking structure. This is that parking structure entrance if you were standing in Argyle and you were facing towards Selma. So Hollywood Boulevard would be to your back. And the entrance is on the left-hand side there. And what you will see in the videos, this parking lot entrance has those hanging indicators from the roof that tell you how tall the garage is, so that if you are driving a tall car, you don't, of course there's fly buzzing around me, you don't run your car into the roof of the parking structure. And I point that out because when you watch the video, you'll actually see that red indicator as a kind of a line through the video, so you know what that is. At the mouth of that parking entrance, there are cameras that are facing the sidewalk. Those are the first view that we saw. And these cameras capture the initial encounter between the victim, Mr. Efron, who you see there, and the defendant, Mr. Mayers. And you can see that Ills is the first one to intervene to try to separate the two of them. And then at the very bottom of the screen, you see 12E putting his hand to try to also intervene and help separate them. Now I know it goes by quickly, and you're not as familiar with all these people, so I want to kind of break it down a little bit for you and show you what the evidence that you're going to receive throughout this case. The first person that you see in that video is the victim, Mr. Efron. The second person who you see, who is instantly confrontational with Mr. Efron, is the defendant, Mr. Mayers. You see on the video that Mr. Mayers is immediately aggressive towards Mr. Efron. He's pulling at Mr. Efron's sweatshirt, and he's pushing Mr. Efron backward and pushes him off camera, out of camera view. The third person that you see, as I told you, is Elijah Ulaner, who also goes by ASAP Ills, or he might just be referred to as Ills throughout this. If you look closely, you can actually see his stage name embroidered on the jacket that he's wearing there. And what he attempts to do is to de-escalate the situation, to get between the two men and to physically separate them. And you'll see that all three of them go off screen for a period of time. Mr. Efron will tell you that during the period of time that they are off screen is when the defendant first produces that semi-automatic pistol from his waistband. He pulls it out of his waistband and he's holding it to Mr. Efron. Mr. Efron will tell you that the defendant pointed the gun at his chest and was essentially trying to point the gun around Ills, who was between them. That at the time that he was pointing the gun at Mr. Efron, he was also threatening Mr. Efron. I'm going to kill you. Keep in mind, these men have known each other for a long time. And Mr. Efron will tell you, in his state of mind, he never believed that he was going to be shot. He never believed that the defendant would actually shoot him. He will tell you that had this been a stranger, someone he didn't know as well, he would have been petrified. As you can imagine, anyone pointing a gun at you would upset you. But he knows the defendant. He knows that Mr. Mayers is not going to shoot him. He knows so much so that he'll tell you he looked at the defendant and said, if you brought a gun, you should shoot it. That's how confident he is that he knows the defendant is not going to pull that trigger. Now, the fourth person you can barely see on this video as they come back into frame, I told you, is Jamel Phillips, who goes by 12E or ASAP 12. And you can just see his hand at the very bottom of the screen. When they come back on screen, and specifically when Mr. Mayers comes back on screen, you can see the gun in his hand. You will hear that that gun that he's holding is a semi-automatic pistol, or has features that are consistent with a semi-automatic pistol. Right now, as it's paused on the screen, you can see that he's holding that gun behind his back. But you will also see the gun come forward in front of his body before he ultimately tucks it back into his waistband. And you will see from the video that there were bystanders. As I said, this is a busy Saturday night in Hollywood, walking by as this confrontation is taking place. You will hear that right after that encounter that you saw, that Mr. Mayers walked away and was walking down Argyle towards Selma. Mr. Efron will tell you that as he walked away, he looked over at 12E, Mr. Phillips, and he saw 12E putting a pocket knife away. And Mr. Efron, and then 12E, Mr. Phillips, walked behind the defendant, Mr. Mayers, and Ills walked behind him as well. So the three men that had come to confront Mr. Efron walked away down Argyle towards Selma. And Mr. Efron will tell you that at that moment, his mindset about the initial confrontation changed. I told you that Mr. Efron will tell you when he first went there, he believed that this was meant to be a confrontation so that they could strengthen their relationship. But having just had a gun pointed at him and seeing another friend putting away a pocket knife, that his mindset changed and he understood these men never came here to try to make peace with him, that it was always meant to be a confrontation. And he decided at that moment that having a gun pointed at him was sort of a bridge too far in their friendship. And he understood he was probably never going to have the same friendship, especially with the defendant, ever again. And you will hear that as the defendant walked away, Mr. Efron followed behind him and was yelling and screaming at him, even though he knew the defendant had a gun. Because although Mr. Efron believed this is going to damage our relationship, he still never believed that the defendant would actually shoot at him.
I'm stopping because, again, I think that's clear, right? I think that that's an important distinction. They walked away and Relly followed them. After he pulled this weapon, no shots had been fired at that point. He followed. I think that that's clear. And in other states, you may encounter other issues if you follow somebody. But okay, here we go.
It's not as if Mr. Efron will tell you that he had some death wish or that he was not scared of guns. He will not come in and say that. What he will tell you, again, is that had anyone else done this, he would have been frightened. But he had known the defendant for so long, and they were close. So he walks down Argyle towards Selma and follows behind the three other men. When they get to Selma, they all turn left, and they walk towards Vista Del Mar. And they end up at that location we talked about, that corner of Selma and Vista Del Mar. And as Mr. Mayers stepped off the curb, he walked into frame of the camera at location number 2 that's pointing towards Selma. Now I want to take you, before I play the video again, I want to take you to that corner so that you can see from that night what it looked like. It's a small street with a parking lot immediately adjacent to it that were full of parked cars. And at 10:17 p.m. when they arrived at that intersection and the defendant stepped off the street corner into view of camera number 2, you will see video from that location. The video that I've played for you already and that I'm going to play for you again is from that location number 2. You will also see, that's the main video that you're watching, but you'll see in the bottom right-hand corner, there's a smaller video on top of it. It kind of has a bluish tint to it. And that video is from another location behind building number 2 where the number 3 is. And the video that you're seeing from that location is identified there by the green arrow. But what's important about that video, because the video does not capture the shooting at location number 3. What location number 3 captures is audio. And it captures the sound of the gun being fired twice. This is the location number 2, where the camera, the video that actually captured that shooting was. You can see the cameras at the very top corner of the building, and it's about 3 properties away from the location that we're seeing. So again, the video is captured at a distance. It's a admittedly grainy video. It's not the most clear that you could possibly have, but it captures enough features that you can identify who is who when you watch this video. So I told you the main video that you're watching is from location number 2, and that smaller location number 3 is in the corner. Before I play the video, I want to orient you to what you're seeing. Along the top is Vista Del Mar. The parking lot is just out of view of the camera at the top of the screen. Along the top left-hand corner is Selma, forms that intersection. The red arrow is the defendant, Mr. Mayers.
Can y'all see that?
And the green arrow is the victim, Mr. Efron. Okay. Now, what you see as the video plays is the various cameras on location number 2 switching between 3 different cameras that are mounted to that building. What's important about that, towards the end of the video, you'll see as Mr. Mayers is running away from the location, running down Vista Del Mar towards El Centro, he trips a floodlight that's motion activated. And when you watch the video closely, that floodlight is captured by both locations. So location number 2 and location number 3, those cameras each capture that floodlight turning on. And when you watch the videos together, you can see that moment in time when the lights flash on, line up. And that's how you know the sound correlates with the video that you're seeing playing at the same time from a different location. Now, I told you, we all know the video from location number 2 is from a distance. If you zoom in on the area where this incident happened, and we will play a zoomed in version of this video, what you see is a very pixelated image. But what even that captures still are the colors the individuals are wearing, which is how you can distinguish who is who on the video. You'll see Mr. Efron on the far left. Ills is just next to him. 12, who's wearing the red jacket, is just next to Ills. And then the defendant, who's wearing all black, is at the bottom of the screen.
I wish I was at the courthouse right now. I want to
understand if you watch this video one time, you may not pick up these features, but as you watch it repeatedly, you'll be able to tell who is who. And you'll also be able to tell when you watch these videos in sequence, because they walk in front of other cameras that are far more clear, that you can easily identify who is who on this video.
Why would you say buy a potato?
So this is the zoomed in version of that incident. This does not have any audio. Now, as we play the zoomed in version, you'll also see that Mr. Efron is struggling with ills. And what Mr. Efron will tell you is that immediately as the defendant turned and pointed the gun at him, he jumped behind Ills, essentially to put Ills between him and the defendant. And you'll see on the video the defendant lunging one way and then the other way around Ills, trying to get at the victim who is holding Ills in front of him. Now, despite how dangerous this is, having a semi-automatic pistol pointed at you and discharged twice, you will hear that Mr. Efron was not seriously injured by this shooting. He has these injuries to the middle knuckle of one of his hands. Mr. Efron will tell you that at the time the shooting was happening, he immediately felt a burning sensation to his hand, which led him to believe that these were graze wounds from one of the bullets that was shot at him.
Or is it from fighting?
Perhaps they were. Perhaps they were not. Whether or not the victim in this case was actually shot or injured by this will not be something that you have to decide at the end of the case. We ask you to wait until the end of the case when the judge instructs you on the law, what elements are actually required to be proven before you make any decision. And to listen to the charges specifically and not consider charges that the defendant is not charged with. In this case, he's not charged with attempted murder, for instance. Now, before I move on, I want to focus in on the last location that I haven't talked about much, location number 4.
I want to look up the charge.
That location is a loading dock for this building on El Centro. It's right at the
I want to look up the charge because he just said that the jurors don't have to determine if he actually shot them or else it would be an attempted murder charge. So I need to look up what the charge is and what the elements are, because assault with a semi-automatic firearm in my mind would mean like he assaulted you with it, like he hit you with it. That's just where my mind is going. But obviously I'm not a lawyer, so I'm not understanding why couldn't it just be assault? That would be the fight. But if you're assault with the weapon, I would, in my mind, I don't understand. I have questions. Anyway, okay, we'll keep going. This is why I'm not a lawyer and I got to go do the research. If you are a lawyer and know the answer, chime in. But I'm going to research this.
corner of El Centro and Vista Del Mar. And what you'll see in the video from that location is the defendant, Mr. Mayers, and his companion, 12B, walking from Vista Del Mar up El Centro towards Hollywood Boulevard. The arrows indicate their path of travel. They're going to come from that corner and then walk up El Centro. The camera itself is in that red circle. And you'll see this video is far more clear. And you'll see features of their clothing that you can match up to the clothing from the other videos that we've already watched. For instance, I mean, you can see just from Mr. Mayer's facial features that he's the one wearing all black. You can see from his facial features compared to the video from the parking structure. And then, as I said, the various features of his clothing, the rhinestones on the hood of his sweatshirt in both videos, and the design, the rhinestone design on the chest of his sweatshirt at both videos. And taking all the videos in their totality and comparing them is how you'll be able to decide on the video who is who. Now, I played the 911 call for you that LAPD received at 10:18, which triggered their response. And you'll see and hear that at 10:27, LAPD officers responded to the 911 call. And as is their duty, they responded quickly to this call to try to, of shots fired in the middle of Hollywood. You will hear from at least one of the officers who responded to that location, and the officer will tell you that as part of their uniform, they wear cameras that are mounted to their chest. And you will actually get to watch camera that captures the police response. After this shooting, the evidence will be that all four of these men, the defendant, 12E, Ills, and the victim, all left the scene. You'll hear that there were at least 2 people who called 911 to report this crime, who were just people living in the surrounding area, not actually involved in the altercation itself. You'll hear that the 911 callers were reporting different information. So the first call would be that the gunshots were fired at Argyle and Selma. The second call would be that the gunshots were fired in the area closer to Vista Del Mar and El Centro. You will hear from the officer that as they responded, they come to the scene looking for a victim. That's their primary focus. Trying to find anyone who needs immediate life-saving attention. Their second focus will be looking for the potential suspects if they can find them. And you'll hear from the officer that as he's receiving information that's taking him to different locations, he's actually going between the different locations and trying to piece together what happened. But what will be important from his testimony is that he is not given a precise location to exactly where this shooting happened. And with the limited information that he has, he and his partners are doing the best job that they can to find any victims, any suspects, or any evidence of a shooting. You'll hear the officer talk to different people who were just out and about, try to figure out what was going on, that neither of the 911 callers would meet with them, and that they searched not only the surrounding streets, but they primarily focused on the parking lot that was right at that corner of Vista Del Mar and Selma, because the second 911 caller had told him, or had relayed that it was possible that the shooting was happening into a car. The officer will tell you that they searched the area and they did not find any evidence of a shooting. They didn't find a victim with injuries. They didn't find any of the suspects, and they didn't find any discharged cartridge cases, which are what come out of a gun after you discharge it, in the surrounding area. But again, they don't know exactly where to look with the limited information that they're given. You will also hear from Mr. Efron that approximately an hour, and he's not precise on the exact time, but approximately an hour after the shooting, he himself returned to the location. Now, at this time, the police have already responded and left. Mr. Efron will tell you that he and his girlfriend went there specifically to look for evidence that this had happened, evidence of this shooting. And Mr. Efron will tell you, because he knew exactly where the shooting happened, that he was able to locate 2 fired cartridge cases. This is actually a photograph that Mr. Efron himself took of one of the fired cartridge cases that he found. Mr. Efron, you'll hear, went to the police 2 days later, walked into the Hollywood police station to report this crime happening. He brought the 2 fired cartridge cases with him, and he gave them to the police. You will hear that the 2 cartridge cases that he brought in were 9mm Luger caliber cartridge cases. However, you will also hear from Mr. Efron that immediately after the shooting, about an hour and a half later, he started text messaging the defendant. And he text messaged the defendant, "You try killing me." That was the first message he sent to him. And you'll hear that Mr. Mayor's response was to deny that anything happened. The defendant, in abbreviation, says, "What the fuck is he talking about? Why are you telling people I shot at you?" Denying that any shooting has even happened. Mr. Efron confronts him again. "You set me up to try to take me from my daughter." And the defendant responds, "I tried to do what? I know you hate me, I hate you too." The defendant responds again, "Stop making shit up." Again, denying any confrontation took place. Certainly any shooting. We have already told you in jury selection, and you will hear evidence, that after this shooting, Mr. Efron sought money from Mr. Mayers. In fact, right, hours after the shootings, this is the next day, November 7th, in the early morning hours, 3:40 a.m., you'll hear that Mr. Efron sent a message to one of his friends saying that he wants money. And identifying the reason why he wants that money is because Mr. Mayers shot at him. You will also hear that based upon these two incidents, the parking lot and the shooting on the corner, that Mr. Efron filed a civil lawsuit against Mr. Mayers. At the end of this case, you will not be asked to award Mr. Efron any money. So that consideration will not be a part of your what you're asked to determine. Moving forward in time, you'll hear from LAPD detectives that Mr. Mayer's home was searched on April 20th of 2022, and that during that search, LAPD detective recovered a magazine for a semi-automatic pistol that was 9mm caliber, and that it was loaded with 6 unfired 9mm Luger rounds of live ammunition. You will hear that these items were found in Mr. Mayer's bedroom closet. You will also hear that there was no handgun that was 9mm in Mr. Mayer's home that was for that magazine. So you have a 9mm magazine, but no handgun to go with it. The last point I want to leave you with before I conclude is that we expect, in this case, that the defense will call Twelby, Mr. Phillips, to testify. At the time of the shooting, again, he's friends with all these participants. He's 32 years old. And it is expected that he will testify that the defendant was in fact the person on the video who fired the 2 gunshots that we hear. So it will essentially be uncontested that Mr. Mayers was the person who fired the gun at that street corner, and that he will tell you the gun that the defendant fired was a starter pistol. That, ladies and gentlemen, is what the evidence in this case will show at the end of this case. As I've said, we expect that the defense will attempt to present an alternative explanation for what happened that night. But we ask you to do one thing, which is, as you evaluate the evidence from both sides in this case, to not leave your common sense at the door, and wait until the end of the case, when you have all the evidence, to make your decision, listen to the court's instructions on the law, and return the only just verdict there is.
Thank you.
All right, folks, we'll take the break now. Please be outside the courtroom doors at 1:30, as close to that time as possible. We'll have you come in, and you will hear from Ms. McAfee. Are you going to do the? All right, please don't discuss the case amongst yourselves or anybody else. Please do not go on the internet.
Oh, looks like we were behind. I didn't even realize. So, okay, I think that there's a few things we need to discuss. First is what he's actually charged with, because that matters, right? Let's go to, they're on lunch also. If that's not clear, they go to lunch. This is, I like LA because they start at 10:30. They're only going to go till 12. They're going to take a lunch for an hour and a half. So they'll be back at 1:30 and then they'll go till 4 and everybody will go home. This is amazing. And then, so if that was an hour and a half, so maybe we'll get the first witness today. Because if Takapina goes for an hour and a half, that's 1:30, 2:30, that's 3. I guess that would leave. I wonder if they're going to do the first witness or if they're going to wait, or like if he'll let them leave at 3 because he's only planning to go until 4. Anyway, we'll see. Anyway, this is what the charge is. Okay, so we see, let me make it big. Assault with a firearm. To prove an allegation of assault with a firearm, a prosecutor must be able to establish the following elements. The defendant, meaning Rocky, did an act with a firearm that by its nature would directly and probably result in the application of force on a person. The defendant acted intentionally. When the defendant acted, he or she was aware of facts that would cause a reasonable person to realize that their act would directly and probably result in the application of force to someone. And when the defendant acted, he or she had the present ability to apply force with a firearm. No injury or firing of the firearm is required under the statute. Let's say that again. No injury or firing of the firearm is required under the statute. A firearm is defined as any device, not evidence, to be used as a weapon from which a projectile. So, okay, firearm can include blah, blah, blah. So a man points a fire. This is an example. A man points a firearm at another person. However, the gun is not loaded. This man could not be convicted for assault with a firearm under the code because the man lacked the present ability to actually commit a violent injury. However, if the same man takes the unloaded gun and uses it to pistol whip, but that's my point, the other person, he then could be charged because it's not loaded though. So I still, Kat, who's in here, is her husband is saying that it means the aggression of attacking someone, not the actual hitting or shooting. But that's the fact that this says pistol whipping. I'm not a lawyer, but implies to me that there had to be an action with the gun. If the allegation here is that he shot him, I don't understand where the assault, like it was never connected, right? The assault, I don't understand it. Yeah, so I'm still confused. I'm gonna have to ask a California lawyer. Let me see if there's another one. Oh, okay, hold on. Let me read this one and then let me read this one. Just because I have to understand this. Because this also is going to matter as to what he's actually facing, right? No, girl, go away. Okay, the assault may take the form of pointing the firearm at the victim, striking or so even just pointing, firing the gun at the victim, or actually shooting the victim. Okay, so this pointing, it seems like that's the space that he's in. Here's some examples. A man who is angry that his ex-wife is seeing another man confronts her outside of her apartment and points a gun at her. During an argument over a parking space, a woman retrieves a rifle from the trunk of her car, pops the trunk, and waves it at the person she is arguing with. Okay. After losing at a pool game in a bar, a man goes out to his car, comes back with a handgun, and tries to use it to club. So that's the actual hitting. Okay, so what he's facing and why this could be a problem for him is because he didn't have to shoot. As long as he brought it out with the purpose, intentionally trying to, and it's reckless, you're pulling out a weapon, being reckless with it, they're probably going to, those shots, obviously the sound, they're arguing that he actually shot it. So that's the problem here. That's the problem he's facing. I think that, Valerie, I think that that's enough. Proving he had this gun, I think, and you know what is really interesting? The defense, I forgot where we were, but the defense specified he never pointed it at him. And I thought it was weird that that was called out, but maybe it's because that's key here. And that's why they're saying the starter pistol, because you need to explain that weapon. The weapon alone, the presence of the weapon alone in that video, him taking it out, that seems like that alone. And then you have this second video that's very grainy. You can't see nothing, but the state is trying. So the actual injury, as we read, the actual injury doesn't even matter. That said, how do you guys feel now? There is no video with the flash. The video that you see, you never see a flash. But as we're seeing, the flash doesn't matter. You don't have to prove that he actually shot, because it's not an attempted murder. It's not, you don't have to prove that he actually shot. It seems like based on the elements of this charge, you don't have to prove that. Drama said, I feel mad. Ha. Well, and here's the thing. He got 2 because the audio, this is what I'm assuming, because the prosecutor said that Relly said he fired 4 times, but that audio, you hear 2 shots. So I'm assuming the 2, that's why he has 2 counts. Each count is 12 years. That's where they got the 24. He was facing up to 24 years, but that's because it was 2 counts. But the prosecutor said, if you are convicted, we're recommending 10 to 12 years. He could be sentenced up to, and you guys know how it works, right? Like if he is found guilty, sentencing will be the discretion of the judge, but the prosecutors say they're recommended. He's guilty. We want 10 to 12 years. And then the judge, decides. But yes, Royce. So they have to prove he had a gun that would fire. That's what it comes down to. And that's why the defense is saying it was a starter pistol. He couldn't fire that. That's why the defense is saying that. That's why that's really the only defense you could use here. Because how else do you, if I see video of you with a gun in your hand, explain it to me. It was a fake gun. And that's why the state is now like, well, we did this report. And the report doesn't exactly match because we don't have the gun, so we can't be 100% sure. But look at this. We found a magazine in his house. That's what's happening here. That's the heart of this right now. That's where we are, I think. Let's look at somebody. I think I'm so curious if they're going to do self-defense. Because the whole for me, right, would be he was walking away. He had already pulled it out though, so I don't know if you still got the problem. But he walked away. They walked away. Relly followed. And because that video is so grainy, I'm going to have to go back and rewatch it. But because that video is so grainy, if he's following and then he approaches him and now he pulls it back out, is it self-defense? Do you go with self-defense? I don't know. What do y'all think, man? Let me catch up to some of these. I don't think we have stand your ground here. I'm pretty sure we do not. Though that's a Southern thing from what I know. Correct me if I'm wrong, but from what I know, that's a Southern, that's that we don't have that here. Hello? Leah's dad. Leah's dad. I don't know much about starter pistols, so maybe we go to a let's go to a starter pistol video. Oh wait, a starter pistol. I think they're talking about like your first gun. I don't think this is like starter pistol. Because this is like for beginners. No. I want starter pistol prop gun. Right? Okay. I'm so behind. Sorry, guys. Oh, like a race, like at a track meet. That's what we're saying. Oh, we do have it. Oh, FDJ is here. We do have stand your ground in California. Thank you. Okay, come on in here and teach the people. Oh, like in the Rust case. Thank you, Roy's coming through. Yes, that was helpful. Okay. So everybody's clear. That's helpful. Yeah, but so now what? How many of you guys are going with how do you feel? I wish I could like bring you up here. I want to engage. I want to ask about how do you feel about this starter pistol defense? I mean, we're going to have to hear the defense's opening, right? So he's about to pull it all together for us. He's about to tell us what they're saying. But based on that charge, man, I don't know. That is so funny. I pray my Google search history is never subpoenaed because Mel have you looking up you got to do the Karen Reed defense. Just say, I actually looked that up 6 hours ago. You got to get that lady. It doesn't shoot bullets. And so their defense, I mean, what they said, obviously, again, we're going to hear him put it together, but the defense was, hold on, sorry, guys. Okay. The defense was he uses it for security. No, your butt did it. You want to change your vote to yes? Oh, what was my question? I forgot I still had it up. Hold on. If you were Rocky, would you want a firearms expert on your panel? This lighting is making me not look that great. It's like all of my imperfections. Yeah, because remember, right? The defense doesn't have to say, the defense they need reasonable doubt, right? They don't have to say they just have to poke holes enough to make somebody think, oh, well, maybe it was a starter pistol. So you got to do what's going to be most believable to a person like you or the 12 jurors that they selected. But remember, they have a firearms expert. But remember, they have, and that woman's dad, and she wasn't a firearms expert, I think, for like semi-automatics. I think it was a different kind of gun. However, I'd imagine you know guns. And her father was like a DA. So that's who you have on your jury. That's always an option. That's always an option. When those injuries, the picture, I hadn't seen that picture. The one I've seen is much softer than that. That injury, after seeing those videos, that injury looked like the fight. It looked like y'all was fighting. But remember, injury is not important here. They don't have the gun, Royce. They don't have the gun. They can't bring the gun in because they don't got it. They don't have the gun. Okay, hold on. I'm going with another. I need you guys' thoughts. Let me give you another poll. Based on that, we haven't heard Rocky's opening yet. We haven't heard his team. But based on where we are right now, should Rocky have taken the plea? Yes? No? There we go. Put your vote in. Oh, this is a good one. Before you vote, hit the like button. Thank you, Tiffany. The plea deal was 180 days in jail, which he wouldn't have served all, but that was the plea. It was 3 years probation, 7 years suspended jail sentence, right? And so you know what that means. He would have done those 180 days. He would have gotten out and been on probation for 3 years. As long as you don't F up, as long as he don't cause no problems during that probation period, after the 3 years, he's off. If he just so happens to cause any kind of problems during those 3 years, that 7 year suspended sentence and whatever is remaining on the 3 year of probation, he serves in jail. That's the way that works. So it was 180 days in jail, 3 years probation, 7 years suspended, like 52 weeks of anger management, and 180 days or hours or something like, I don't know, something like that for community service. So that was the plea. In total, he would have, I mean, as long as everything went right, he would have been in jail 180 days, but probably less. That was the plea. But I will say, when we were in the hallway, I think it was Megan maybe, said, why didn't he take the plea to his attorney? I hope this is okay to say. It wasn't like nobody said off the record. But his attorney was like, he gets a felony on his record. He loses out on deals he has because he is of this felon and he is pleading guilty. He was like, there's more at risk for him than just, 180 days. He had more to lose. And that's why he said no. So that's what he was on. That was a little hallway chatter. And something you may, if you're not guilty, if you didn't do it, but they have this video, do you take the deal? Or do you say, take the shit to trial? That's a good point too. There's also this civil case. Thank you, Adventurous Spirit. There's also the civil case still. Now, if you plead guilty, okay, he pled guilty, run him his money, right? You plead guilty and the bar for civil is much lower anyway. So he gonna have to pay that money too. How do you guys feel about the text message? His friend was like, "Are you sure?" Which also gives that wasn't believable. But the first thing you say is, "I'm gonna get this money from him." But because he shot at me, like, I don't know. I'm so curious about that part. Like, as a juror, what are you thinking? Sarita said, "I would have paid that boy to shut his mouth before he left the crime scene." But there's also this history between them. So it feels like, this is just, personal opinion. It feels like ego. It feels like, man, F you. We was friends. You did me dirty. I'm not paying you. All that stuff comes into it. And so are you thinking straight, which is what even I think the prosecutor said, like, I just hope you're really thinking about this because hello. But do you fight it? Is this enough? You had those text messages. He did, wait to go. Is that enough? The hiccup for me is the way that the charge is worded. And when the jury goes back, the question that they're answering, that's what matters. You're answering, did he have a gun? Did he pull it out? Did he do it recklessly? Or whatever the elements are. Those are the questions you're answering to get to verdict, to the guilty. Not, was he only doing this for money? Not, was he actually even wounded? Not, this was a waste of time. Should this even have gotten here? Yeah, I mean, unless you're the YSL jurors and you're like, man, I don't know. It's just, I think, a bunch of things to consider. Let me see what y'all talking about. I don't even know, spilling the tea, what you're referring to, but reading this comment just is hilarious. His friend is weird. And here's the other thing to remember. Relly's going to get on the stand. Relly is going to testify. We have to watch when Relly testifies because I wonder if the lead detective is first or Relly is first. I'm curious who's going to be the first witness. And it could be somebody other than the two people I just said. I'm just in my head like one of those. But regardless, Relly's going to get on that stand. This is my opinion. Depending on how Relly does is going to determine if Rihanna comes next week. If Relly gets up there and feels credible and feels sure and feels definitive and is not up there talking about how old is you, I'm grown, I plead the fifth. If he on there feeling credible, Riri got to show up. Riri got to go. She got to be Riri in the courthouse. I'm going to try to go. I'm trying to go next week. I hope they go dark on Monday because Mondays are bad for me. But I'm going to try to go back. I just, I got my mom. I got to do pickups and all that kind of stuff. The original projection of the case was supposed to be 15 court days. But then that got knocked down to 10 to 12 days, I believe. But even now, I mean, honestly, that feels like a lot to me. I don't think it's going to last 10 to 12 days. I'm feeling like 8. That's based on nothing. And I'm not a lawyer. Okay. So I could be wrong. I'm probably wrong, but in my mind, this feels like 8 days. The defense only has 2 witnesses. The longest, they're going to have a couple officers, but like the real people that matter here, Relly's testimony, lead detective, this ballistics situation. Also, I'm not an attorney. There's many things I don't know, I'm sure. So someone knows more than me, I'm sure. Anyway, I don't know how many witnesses that the state has. The defense so far has said only 2. Obviously, if they get this firearms person, they'll probably have 3. But I don't know how many the state has. For sure, Relly, and for sure, the lead detective. I imagine whoever's going to discuss this firearm thing, but actually that may come through the lead detective. I don't know. I don't know how many they have. And I don't remember how many total testified at the prelim. I don't remember a lot of them though. So his lawyer, let's be very, yes. He does have good lawyers, right? I call him Brolick. He's very like East Coast, that lawyer. Tacopina. He has represented Trump before. One of the jurors during jury selection, the state asked, the prosecutor asked, not only after he had asked, are you familiar with ASAP? Or are you familiar with Rihanna? He also said, how about any of the attorneys? And one of the jurors was like, I've seen Tacopina on TV, like on MSNBC, talking about law stuff. And so he was like, you know, that shouldn't give him or his side or his team more credibility just because he's been on TV. But that's the other stuff that, you know, you have to keep in mind. Akira said that Riri card might not work, child. It's not all white. It's not, there's no black people visibly. I mean, maybe somebody over there identifies as black and I just couldn't tell, but visibly there were white people, Asian people, some people look like they are of Asian descent, and other people look like they are of Latin descent. So it looks like the makeup, according to me, okay, there could be some Armenians there because this city has a lot of Armenians as well. So this is all, and I always feel bad doing this because it's like, you don't know what people are or how they identify. So this is my very ignorant, only to the eye can see, based off of, you know, my life's experience. It is white people, people of Asian descent, people of Latin descent is what the jury looks like. It doesn't appear, nobody appears to be black. My shirt says Self-Love Club. I think I got it at Target. Oh, I should get my, I'm not a lawyer, but my little thing. I don't remember how much the civil case is for. I have it on my computer because I was just looking at it yesterday. I'll have to look it up and see. I don't remember off the top of my head. Thank you. Thank you, Robert. Mr. Tight Suit is hilarious. Listen, that suit, I said, okay now. You better not bend over too quick. Better not eat no cookies at lunch. That thing might split. The Bayesian sensation will be there. Hilarious. Yes, my air purifier. It must be good because you can't even hear it, but it's been going this whole time. It's on. That's hilarious. If I show up and there's a mistrial, that's going to be funny. I'm definitely showing up though. I'm going back next week. I'll be back in the courthouse. I was going to say something else. I'm trying to remember. While we are, Rice Street, gifting some, shout out to Rice Street for gifting some memberships. If you get a membership, obviously say thank you. I appreciate you for gifting them. You being called Rice Street though is sending me. Okay. No. And I'm finna block you ATL. See, now I gotta delete your comment. Because I gotta go back next week. Unrelated, but something I just been meaning to say. The Tupac trial is gonna start, I think, in March. And if you're on Patreon and you've been around for a while, you probably remember when I read that transcript, the Keefe D transcript from his interview. The wildest thing I've ever read in my life. Okay. So just know that that one's coming. And I might be into it. I might be into it a little bit. Because there was so much information that I didn't know. And it was only when you read the transcript, I was literally like, oh my gosh, I didn't know that, like I didn't know. So anyway, just know that that'll be coming. I'm on this chair. That'll be coming. That's funny. No, it's Rice Street. That one's happening in Vegas too. That one's gonna be. It's just the facts of it. I think are what a lot of people don't know. No, I thought Karen Reed is April. Tupac is March, and I think Karen Reed is April. It's absolutely insane. You know what was surprising to me is that Keefe D literally lays out what happened, and I didn't know. I just didn't know. But he lays out where they were, what happened when they saw him. They flipped this Yui. And then he in there singing, and his attorney is like, Can I talk to him without you here? Can you go away for a second? And then he's like, Keefe, he talks a lot sometimes. Keefe, I just need you to answer the questions that are asked. I don't need you to answer anything more than that, okay? So just relax. He talked way too much. He was in there. Who did you? Oh, I don't even like him. I was trying to pull up on him too. That's why it literally his attorney is like, only answer the questions that are asked. You are talking too much. Oh, excuse me. Yeah, it was. What a time. Okay, so if Karen is April 1st, I think. Excuse me. Let me look. I think we're good, but let me look. Because I need to go out to Boston myself for, excuse me, goodness, for Karen. Let me see what it is. Oh, so Keefe D starts. Oh, there should be time. It's mid-March. There should be time. It should be time. It shouldn't overlap with Karen because I'm all in on Karen. I need part 2. I know there's been a lot of motions and I haven't been discussing them, but just know we gonna be ready. Yes, it's on the calendar. Oh, good. Let me eat another Ricola. Anyway, there was something else I wanted to mention from being at the courthouse. If I can remember. Yeah, the Nazaya one, somebody said that the trial, I should look it up. Well, since we're sitting here, if you're on the replay crew, first of all, shout out to the replay crew. Everybody don't get to watch this live. So if you watch this later, appreciate you for watching. Let's see. Yak is going back to court, I think February 17th. Y'all got me going off top of my brain. I write stuff down because I don't remember. But it's February. What was I about to look up? Oh, Jarvis Butts. And where is his case? Hold on. Yeah, because they said the trial had been, I hadn't seen. Let me find, let's go to his case really quick and just see. There's not been real updates because, this kind of stuff takes forever anyway. And so just to give you, let me give you context. What everybody has been reporting on for Nazaya Harris and Jarvis Butts was the preliminary hearing. For context, ASAP Rocky's preliminary hearing for this case we're in now happened because I went to it, right? So that happened 23. Was it 23? I'm going to tell you, because I don't want to be wrong. Sorry, I'm coming. I just had it the other day too. And I'm still going. Still going. Okay, so it was before all of this. It's because I got to go through all my YSL stuff. Okay. So November 21st, 2023. Okay. So that is when, that's when I went to court. Oops. For ASAP. So for perspective, ASAP, his preliminary was November 2023, and here we are 25, right? And granted, ASAP's case was supposed to happen actually November 24. But he pushed it because he had like a concert or something. So it got pushed to now. So it took a year. So what we all just watched of Jarvis Butts is just the preliminary. And so I'm going to look it up because maybe it is going to happen in March. Maybe they just move faster because LA is LA. But my point was that preliminary hearings are like very early on in a process. It's literally the judge determining if there's enough, for this person to go to court. So let's see. I always forget that. Let me find what I need. Anybody remember the county off the top of their head? They're saying October. Anybody remember the county that that's in? Oh, it's Wayne. Never mind. Okay, let's see if I can see. Oh, I always do this. Okay. Oh, I should share my screen. So let me show you what I'm looking at. Can y'all see that? Okay. So we had the bind over, we had the arraignment, the disposition, right? Order for production of exam. So March is just a calendar conference. It's not the trial. March is just a calendar conference. So they're going to go there. They're going to talk about the calendar. They're going to talk about dates. They're going to talk about what's coming up. They're going to talk about what they need. There's going to be motions filed. There's going to be hearings in this case. There's might be some experts that have to be qualified. There's going to be stuff that happens before the trial itself takes place. Again, I can't say how long because it's a completely different county, different than LA, like who knows. But they have to, before the trial, they have to prepare. You know how all this stuff about evidence hasn't been turned over. When was it turned? All that stuff has to happen. They have to be turning over this stuff. There's going to be deadlines for that. The defense is going to object to some stuff. The state's going to object to some stuff. It's going to be this back and forth before they actually have it. The thing you will know when this trial is happening, it's going to say jury trial, and it's going to have the date and the time. It's going to say jury trial. All this stuff right now it's not the trial. Mm-mm. And before the jury trial starts, it's going to say final pretrial hearing. Okay. Before the trial starts, there's a final pretrial where everybody's going to come in and they're going to say, okay, we're starting on Monday. We're going to start. The schedule is going to be Monday through Friday, 10 to 5. And how long is it expected to take? It's going to take all that stuff. That final pretrial is when you're like, all right, we own. But right now it's too early. But I imagine there's going to be a lot of coverage, and I hope there is. I hope everybody is there and covering this and talking about this because it's insane. Don't ever let me forget Karen Reed is April, okay? Just I have it on my calendar, but just don't ever let me forget. Rice Street became a member. Rice Street, I hope you fixing that jail up. Yeah. Waiting for his turn. This piece of hair is making me crazy. Yeah, he in there waiting on his turn. I'm sure probably, talking to lawyers, I guess. You know what is so funny, Katrina? We're just chatting now, by the way. So feel free to go get your lunch and come back if you're on the West Coast. Or I guess the East Coast people, y'all work day almost ending, huh? People on the East Coast, y'all getting ready to go home? Wait, that's funny. Rice Street said they need a few more million to fix all the issues in the house. What's going to happen, what's going to be difficult in that case, in the, what's her name? Naziah Harris, right? This Jarvis Butts case, without a body, they have to prove that she's not alive. And this is, I'm not saying you're wrong, Katrina, but you're going to get people on the jury who are going to be saying the same thing. What if she's still alive? Right? The state has to prove, in order to get him convicted, they have to prove she's dead. And is the defense going to be able to give enough reasonable doubt for just one person to be like, she could still be, what if she's alive? And that could be enough to get him a hung jury mistrial. I think that is going to be the hardest thing in that case. I think that there are people who will have hope, right? Hope that she's alive, but that hope is actually bad for the state. They don't need you to have hope that she's alive. They need you to believe that she's not alive. So I think that that's going to be challenging for them. That's going to be challenging. Because I just think people's natural inclination is to have hope and to say, but what if? I think they naturally do that. Exactly, right? And if the defense starts saying somebody spotted her, or the aunt, now people in the jury box are like, what if I don't want to say that he her, because what if she's alive? And so then the state's case falls apart. That's why these hypothetical, that's why these I can't think of the word, but these kind of cases, it gets hard. Circumstantial is what I'm trying to say. Without a body, you got to prove she's dead. And then you have to prove not only that she's dead, that he killed her. Tough. Exactly, right? And then if you start bringing up she's trafficked, if somebody on that jury believes that, they could be like, nope, not guilty, because I don't believe he was, assaulting her. I don't believe she's dead. And that means if you don't believe she's dead, that means you don't believe he killed her, which means he shouldn't go to jail for killing her, because I don't believe she's dead. I hope what I'm saying is making sense. But anyway, Yeah, I mean, he does have other charges. I'm just talking about Naziah specifically, but he does have other charges. And the biggest charge for him is her not being alive. Yeah, all y'all are asking the good question. So I was going to look through this book and see if there was more things I needed to say. They need to dig up his garage. I think them hoping and them knowing are two different things. Hilarious. Well, if we still have, 40 minutes? I might end this stream. I personally hate long streams. If I see a stream that's 8 hours, I'll be like, what was y'all doing? So we're already at 2.5 right now. I think I'm going to end this one. Maybe I'll get some food and then I'll start back at like 5 till. So that it'll be, because that one's going to go till 4. So it's going to automatically be longer anyway. And I still want to do like an actual recap. I'm doing a lot, but I want to stream this and then I still want to like recap it. So I'm going to get off of here. Y'all go be productive. Don't get fired from your job. I'm going to be back at like 1:25 my time. So like 5 minutes just to make sure we're all in here. Got the video up. See y'all in a minute. All right, bye. See, Savannah then forgot to eat lunch and stuff. Go eat some food.